All right, hey guys, welcome back. So today we're going to talk about chapters 5 and chapter 6, and there's going to be a bunch of terminology and legal stuff. Remember, this is the second week in our kind of legal series about ethics stuff. One thing I will say is I was scanning back through the book, kind of getting ready to remember what I was going to talk about, is going through the book is really going to help you understand the very specifics of the code. Again, here I'm kind of giving you this high-level lecture of the concepts. And then in class, we'll practice this stuff, but it'll be really helpful if you read through the chapter, make note of all those specific codes and what they mean and what they're for, and then go find them on the actual code document. Luckily, they're still up to date because the ethical code is still consistent with what's in the textbook, although that changes from time to time. So you want to make sure you're not using too old of a book. But if you're with us in the same book, we're fine. But when we get to class, I'm going to ask you to apply those things. And so you'll want to have a good understanding of what's in there and how it relates to this concepts of documentation and privileged communication and confidentiality and that kind of stuff. So without further ado, let's go. Wrong button. That's the one. Oh, if only. So I imagine there's probably nobody watching this who's not in the class. But if somebody did come into this, they'd be like, who is this bumbling idiot who can't even click the right buttons? And then they'd show up. If they ever show up to class, you guys would be like, yeah, this is kind of how he is. This checks out. This guy just does this stuff. So whatever, I'm not changing it today. I'll work on it. It'll be better for you guys next time. How about that? Okay, so some terminology. So privacy. Most of us know what privacy is, but there's here's something that I pick out from our discussions in class. Our concept of what we think is moral and right and good is different than what is required by HIPAA laws, by ethical codes. And so there's this, it's a different level of requirement to keep things private and safe, just because that's how you maintain trust. And therapy doesn't work if there's no trust, right? It just can't really work if you can't build a relationship based on trust. And there's this assumption, if not outwardly expressed, expectation that things are kept private. Remember that term we used, we've talked about several times in class, borrowed from Brene Brown, story stewardship. You tell me the details of your life and I'll be a good steward of that, not by lipping off to all those other people about it, right? So that's what we're talking about when we say privacy. Confidentiality is that requirement by the profession to maintain things from client to client between sessions. That came out weird. It's to keep things secure so that information doesn't get shared or spread around. Now, the interesting thing about this is that before 1991, there was, I wasn't around at that time in the profession, so I might be wrong about some of the details here, but before the internet age, there wasn't quite the same focus on confidentiality in terms of the way you do your work. There was this privacy that was expected, and you were supposed to keep things private because everything needed to be safe and within the bounds of the counseling sessions. But it wasn't the same. In 1990, I might have the date wrong actually, but I think it was 1991 when the Health Insurance Privacy and Portability Act was passed, HIPAA. That came around because that's when the 1990 technology boom happened, and all these companies were creating, basically giving some flesh on the bones of the architecture of the internet, meaning people were using it for commercial purposes, for data transfer purposes, a whole lot more than they were in the past. So insurance companies were sending back and forth information, which allowed for faster billing, faster payment of services, more communication between providers, better integration of services, and all those things that hospitals do in the background. And they weren't being very careful with the information. When counseling picked this up and said, hey, this applies to us too, because we're healthcare providers, there was this expectation that when we store data and secure data, it has to be to ourselves. It only is for that one person, their provider. So this different conversation about confidentiality came out in a different way. And it became this kind of the way you run your business, as well as just an ethical obligation by the field, which was sort of adopted as now it's these separate things between confidentiality, the professional version, and privacy, the very therapeutic and intimate thing that happens between people. So hopefully that makes a little bit of sense. The last term here that's behind my head is privileged communication, which basically means it's a legal term that says everything that you say in this room is between you and me, and nobody else can know about it. However, in the case of counseling, it's a little bit different. Attorneys have ultimate privileged communication. If their client says, I need you to defend me in court to get me off for murder, and he was like, and you're the attorney, and you're like, well, did you actually murder him? And he's like, yeah. But don't tell anybody that. The attorney has ultimate authority to not tell anybody that. His job is to get that client off. And if he says, yeah, he actually did it, but I don't want you to charge him, like, that doesn't make any sense, right? So it's kind of like having immunity from people asking questions and finding out information. We have privileged communication to a degree. This is where the limits of our confidentiality are. And when we do our informed consent speeches with our clients at the beginning and throughout sessions, when we say everything is confidential, everything is privileged communication, it's immune from people finding out about it, except in these rare cases of abuse to harm to others, minors, vulnerable adults, or a threat to yourself, or if there's a subpoena from court and the judge says, hey, I want you guys to have your therapeutically, to trusting environment, whatever that works for you guys. But at the same time, there's this situation that we have to deal with, and it would be really helpful to know that information. So judges will ask if they have to get a subpoena. We'll talk about what that means too. So that's what privileged communication is, if you ever hear that term. So let's dig into what this term confidentiality means a little bit more. We agree to confidentiality as a society because we believe that the benefit of privacy is, in some professional relationships, outweighs the potential harm in not knowing. In other words, these are not only ethical obligations, but laws of the land, because enough people have come together and said, in order for therapy to work, for people to get help in these services, it has to be protected. Okay, so like, it's not just the profession that says, it's not just our state, it's this like social pact that we all say, we don't want doctors to go talking about all the medical conditions because some of them are kind of embarrassing, right? Some of them are not anybody's business. And especially for therapists, you don't want people going out, or therapists going out talking about their clients, because it could do potential harm to people. So there's this need to professionally protect people's anonymity or privacy or confidentiality, right? So it's bigger than just let's make sure we lock up our records. This is essential to the practice of modern healing, I guess, for lack of a better term. When it comes to confidentiality complaints, like ethical complaints against confidentiality, they aren't that common. However, remember the articles we looked at the very beginning of the semester that pulled up the most common ethical complaints against counselors? This is kind of up on that list of like breaches of confidentiality. Most of the time, I think they're pretty much accidental. Like, therapists are not out there doing this on purpose. It's a little blind spots in our practices, or I just need to vent and get this off my chest. And then it gets out to somebody, and somebody's not as careful as you should be with your clients, and things happen, right? So it happens a lot with, and I shouldn't say a lot, it happens with the transfer of information from one provider to the other. That's why we have a release of information that sort of protects you as the counselor from the client coming back and saying, well, I never told you could say that kind of stuff about me, or transfer those records to that person, or do it in such a way that it would get out to other people. So there's a lot of fine details about how this happens, but they're really not all that common because most people have integrated really good practices into their work. So take this class, take in what you're hearing, and then when you get to other places like your practicum experiences and your internship experiences, you'll see people describe, this is how we do this, and they'll show you the practices that go along with the principles that we're talking about here. Generally, I think because we therapeutically know that privacy is important in order for our services to work, and because we've really integrated the law of confidentiality almost to a point of paranoia. And I don't say that lightly, because this paranoia is a good thing because we have to have it therapeutically and professionally. I almost think there are some times where I'm like, maybe we're not anxious enough about privacy and confidentiality, right? Some of you have heard me say this before, but I listen to like cybersecurity podcasts. Like, the most popular one is Darknet Diaries, and the guy who hosts it, he's always talking about privacy and security because he's dealing with hackers and people trying to break in and steal things, right? In our world, we don't have so much of a burden to protect against people trying to steal our stuff, steal the information about clients. It's more about us slipping up. And yet, I think we've been vigilant and maybe hyper vigilant enough to do a pretty good job about this kind of stuff. So it's not something you need to really be scared of. It's not something you need to worry too much about, but you should be a little bit anxious about it because it really is important that you have good practices. And once you get to your clinical practice sites, like your internships and stuff, they'll help you see what that looks like. You adopt those practices. It's good to pay attention to them. And when new situations come up, follow the procedures. But we've done a pretty good job of integrating that mostly. And I say mostly because some of you are going to get to a site and you're like, they're always talking about clients and they don't lock up their stuff. And if you have this sort of concern going in, you'll be in a good place to protect yourself, even if your site can't do it for you, your work can't do it for you. So remember when we have been, how we've been talking about, we wear these different hats when we're doing an interview with the client to gather assessment data. That's a little bit different than, because we're trying to gain information. That's a little different than when we're doing counseling and we're doing a whole lot more listening. Or a school counselor's hat is different than a therapist counselor's hat, right? When I'm in the capacity of professor, it's different than when I'm in the capacity of therapist, right? So there are certain kinds of hearing about your struggles as students and hearing about your going through your education that's different than what I would talk about or ask you about if I was your therapist, asking more intimate kind of details, that kind of stuff. So we wear these different hats. That's what this first point is talking about. That means you have immunity when you're acting in the role of a therapist or this privileged communication stuff, but not when you're not acting in the role of a therapist. So if a friend comes up to you and says, I'm not paying you to be my therapist, but I want to tell you something and can you keep it private? You're not under the same requirement or obligation to keep things private that you are when you're a therapist. Now, you might have the principle or value that you want to keep things private because that's sort of the thing to do, but there are going to be situations in your personal life where you're like, just because a person is telling me all this stuff doesn't mean that I have an obligation to keep it private. I might want to share it because it's not really my burden to hold. When you're in the capacity of a professional counselor, you have the burden to hold that, whether you like it or not. You're taking on that task, that role as a counselor. In your private life, you don't have to do that. So that's one of those clarifying differences. And I have friends that I don't know if you guys have this. I guess I don't have that many anymore because I kind of made some boundaries in my life. But certain people will tell me stuff and I'm like, I don't want to know this about your private life or your wife or your girlfriends or whatever. I don't want to hold that for you. And they're like, well, you'll keep it private, right? And I'm like, I don't want to be expected to keep it private. I don't like secrets. So if you don't want this out, don't tell me. It's not like I'm going to go sharing it with a bunch of people, but I'm also not going to hold it if someone needs to know it or something, you know what I mean? So because I'm that transparent in my personal life, doesn't mean that I'm not transparent in my professional life. Those things are different, right? And they can be different, and that's okay, because of the boundaries that we may need to set with people in our lives, something like that. So some common myths about confidentiality is clients think that everything is confidential. Again, they have this sense of like therapy is based on trust and privacy. They know that, but they don't know the professional requirements to, if there's harm to self or others, fumbling over my words here, harm to self or others, harm to vulnerable adults, children, or the records subpoena from court, something like that. So that's it's really important that you share that with people. And more importantly than just sharing in the beginning, you have to be able to communicate that stuff to clients as you go along through the counseling sessions too. Imagine if I just said, okay, I'm read the syllabus the first day, walk through the whole thing, and then I'm really never going to talk about it again. If you ask questions, I'm just not really going to share information with you. That wouldn't really be that helpful, right? Because you can't learn everything in one day. It doesn't make sense to do that. So it's an ongoing conversation. I think we know that already. I think I will say this thing behind my head here. Counselors generally think because we think everything should be private and within the bounds of this trusting relationship, oftentimes we get really confused about if a client asks for their records, do they have the right to those records? I mean, it's their life, it's their story, it's their medical record, right? Do they have the access? Sometimes we may withhold that information from clients, and there are reasons why you may do that. Especially if a client, you're like, they're going to be using these in a way that's inappropriate, or I don't know, like they were here for a court, they were required by court to come here, and their diagnosis is something that I don't think they're ready to hear about. So, and I don't want to release these records to the client, but I'll only release them to the court. There's all these weird situations. So this is where the rubber meets the road and things get really ethically difficult of who owns that information, whose story is it, and who gets access to stuff like that. So it gets tricky. The principle to understand here, and I'm going to get myself out of the way again, is that confidentiality belongs to the clients, not to us. So what does that mean? That goes back to this idea that it's their story, it's their information, it's their life. They get to say who gets to know and who doesn't. That's why we have them sign releases of information. If they want somebody else to know this information, they can give us permission. We don't get to make those decisions for them. We have to act on default. Everything's private, everything's confidential, except our legal obligations. And the client can decide to do what they want with that information. Now, they're all little nuanced, different stories here when it gets to the actual work, but that's what we can hear in principle. Privileged communication. We're now switching from confidentiality to privileged communication. I think we've kind of already explained it here, but privacy is essentially a Fourth Amendment right? We have a constitutional protection from people knowing our business. In other words, think all the way back in history that the government could control people, do what they want, and that there's probably people in this room who are like, well, that's what's happening now. I'm not going to get into the politics of current day, but the reason people cross the pond all the way over here to America to steal the land from the Indians, not to be, they're Native Americans, not to be politically controversial, but we commandeered this land to try and start some new society because we didn't like the control that the monarchy in England had over the people, right? So the Constitution was written to say, you know what, that's too much power in the hands of people who could potentially abuse it. So people have the right to their own privacy. It's baked into our nation, our national values. It's baked into our profession. It's really baked into how we understand human-to-human relationships. So the reason we have these exceptions is that if the interest of the good of the whole society outweighs the interests of the individual, then and it's a high bar because it's baked into our Constitution. I say baked, it was written into our Constitution. If the interests of the society, like in the case of someone's going to hurt somebody, then people need to know about that. And that's sort of the way we've organized this profession and how it works. Some more things. Our privileged communication comes from legislation, recognizing that counseling couldn't benefit people without the promise of privacy. So even in our legislation, it's expected there's privacy. Remember that Tarasoff decision we talked about a few weeks ago? The Tarasoff decision was like, well, yeah, but what about these certain circumstances where it's literally life and death? Isn't there some obligation for therapists to help protect the public outside of the sessions too? That's what this is about. Let's see. Oh yeah, fun fact. Before World War II, no mental health professional had privilege. If a person was doing therapy with somebody else, there was no expectation that therapists had to keep that private. Like back when Sigmund Freud was, I don't know what he did, but he smoked a pipe or cigars and sitting people laying on couches and stuff. He didn't have to share any of that. He could tell all kinds of stories about clients and patients, and it was like for the interest of medicine or something like that, you know? It's kind of this double-edged sword. You know how you guys sometimes say things like, or maybe this is my complaint, I don't know, but we say things like, it'd be really nice if you could see therapy in action, but it's really hard to do that because it's all confidential, right? So we can't just like record client sessions and then show you guys and be like, see, this is how it's done. But there are medical schools that have operating tables where there's like literally balconies of people looking over, watching a person get surgically fixed or whatever you call it, cut open and dissected, basically. I don't know. Lots of blood and guts and watching over the top of it, right? Now it probably happens by video. But the point is that when you're learning how to do dissection physically, you can watch and be a part of that process. And medical doctors, the Sigmund Freuds of the world, didn't have they could let people watch in on therapy too and learn that practice. And now we have these boundaries that we've put in place for very good reason, and it makes things harder. So we can't just show you training videos. It's one of the things that makes this education so hard, is that I would love for you just to sit in with clients and watch this and show videos and have live demos and all that kind of stuff. We just can't do it. And so you guys have to go through this long slog of a process of like learning these abstract concepts and then only later applying them in practicum internship and beyond. So I thought it was a fun fact. Hopefully you're having fun. You can do some fun things with it. Kidding, I don't know what you'd do with that. Some states still need reform to ensure privilege for all mental health professionals, not just psychologists and psychiatrists. So there's still, in terms of legislative advocacy, there's still some work to protect the work of counselors and social workers and marriage and family therapists and that kind of stuff. Psychologists and psychiatrists have done more of this advocacy work because they've been around for longer. So just so you know, it's not like a guaranteed thing that everybody has. There's still work to be done. So I'll leave it at that. What are those exceptions? We've talked about them. I kind of rattle them off on my fingers when I go through them. But there are exceptions to confidentiality and privileged communication. One of them is a client waiver of privilege. There are certain circumstances in which clients can say, I'm going to give up my right to keeping this stuff private. It's not a good idea in like 99.9% of circumstances, but there are situations where people can do that. They can give up their privileges. I can't really think of a good example right now. Maybe there was one in the book that I had read at the time, so you guys can bring your examples in from class. I can try and think of other ones too. But there are always these weird circumstances that relate to, like, I don't know, like, I'm trying to think of a good one even. I imagine when you see therapists doing podcasts with client, like real sessions on a podcast or something like that. I imagine that there's some kind of documentation that people sign and sort of waive their privacy rights, that kind of stuff. But I don't know. I can't really think of anything that comes to mind at the moment. If there's a death of a client, posthumously, the information can be released for certain reasons. So that's an exception. Sharing with subordinates or superiors. In other words, in order to do the work of counseling, you may need to give record access to billers and administrators and people who make appointments and that kind of stuff. It's also kind of like when someone calls in and says, hey, I'd like to see a therapist. And the person in the office says, well, can you get like just a one sentence, tell me what this is about or what you'd like to be seen for so I can make sure you get to the right person for you. That kind of information doesn't have the same level of privacy or expectation of privacy, that kind of thing. Supervisors as well is a big one. You can generally share varying levels of sensitive information without breaching confidentiality. In other words, if I'm going to go consult with somebody, and it gets sticky here, so try not to take all of this as gospel. Take this all with a grain of salt and ask questions about this later on. But if I'm going to go consult with somebody, is it possible to say, hypothetically, in a situation where I have a client who has a spouse, and they're having this kind of disagreement, hypothetically, how would I handle that? And if you can maintain the privacy well enough, it's okay to ask questions to people and to get support and help. The question is there a risk of breaching confidentiality? Could that person put together those details of who those people are? And we run into situations like this all the time, especially online. This happens on Facebook groups all the time where someone's like, I'm looking for services for somebody who, I don't know, a male, age 43, who wants to see someone with, who accepts Blue Cross Blue Shield, and they're bringing their 2 kids in to be seen as well. If you were to do a little bit of open source intelligence, as the cybersecurity community would say, and you go on Google and you look at where is that therapist from, who has, who are some people who sort of match the description of middle-aged persons. It's not everybody in that community, especially if it's a small community, who may have two kids that go to public school, and that you can do some of that digging. And so that's why people get really, really, I don't want to use the word paranoid. I'm going to try and get that one out of my lexicon, but where people get really vigilant about, like, just don't use that much detail. Anybody who can see a guy with Blue Cross insurance, that's probably enough to say, hey, I need to consult with somebody to get some help for this guy, right? So there are ways to do that. And even if you need to talk about more details than that, you can talk vaguely, very, very, very vaguely, just to make a referral online. If you're doing it over the phone, you can maybe use a little bit more details, like he has two kids and they'll come with him. If you're doing it with a person who has their own expectation of privacy, like another therapist, there's another level of okayness with it. And if it's your supervisor who's on record as being vetted by the state of Wisconsin as being an approved supervisor, there's even more ability to talk about those things. Same thing in class. So as we get there to those different levels, you're going to be practicing, well, how much can I share and with whom? That's part of the finesse and the skill or the wisdom of learning how to do this work. And that's what you'll get some help with too. So let's see. I'll skip over the rest of that part here, but just for the sake of time. We're not going to have this conversation right now, but this part right above my shoulder here, coordinated services. If you need to coordinate services, remember what I was saying about the early 90s and hospitals sharing records to help facilitate integrated services? It might help to send something over to another counseling center if a client is transitioning from, like, say, inpatient to outpatient. In that case, it might be worth transferring some records over a secure line, but there's still a risk, right? So there's some pros to this, but you're also taking a risk. If you don't need to transfer those records, then don't do it. Or if you can drive them over because you're passing a different office or something, like, there are ways to be more secure and less secure. And you just get to weigh out the pros and cons of what's really facilitating integrated services to help this client, something like that. So there are exceptions to privacy, and I won't say it's exceptions to privacy because you're not, like, violating someone's privacy. You're helping them get the care that they need and taking a risk at the same time, and you're weighing that out. So more exceptions when there is danger to self or others. We've already mentioned the Tarasoff decision that kind of led to this situation that we have now. We have these three duties: the duty to warn, the duty to protect other people and our clients, and the duty to report. So those three things too. We must be vulnerable and assess the risk. I think that's probably sunk in well enough by now. I've made that point enough times. It usually freaks people out. This class generally just inherently scares people because it seems like there's a lot of responsibility. And there is a lot of responsibility. And so being a little anxious at this point is a good thing, so that later on you can have good practices. So you can say, I'm practicing safely. I'm making good, sound, ethical decisions. So now I don't have to worry about it. I'm okay, right? But there is an inherent vulnerability in that process. And part of the reason why I'm trying to push us into these places right now in class is that I'd rather get that out of the way now so that you can do it while we're in the support of not seeing clients and having plenty of people around you to support you than being out on your own too. So there's a little method to the madness. If there is a communicable life-threatening disease. Now, this is one that we may get into later, we may not, but imagine if you were a school counselor and you were responding to an active live shooter on some school grounds. That's not communicable. Communicable is more like, if someone's HIV positive and they're telling you that they're going to go sleep with as many people as they can before they die because they have 6 months to live or something. That disease comes with the death sentence, right? So that's what communicable means. But in either of these life-threatening situations, there's something that says, I think I have a duty to protect other people and warn other people. Now, in the case of an active school shooter, even if the shooter is not your client, but you have to go out and sit on the curb with parents and kids and console and support and help, these are situations in which confidentiality is not quite the same thing. In other words, you can provide support publicly in a way that doesn't like ask people their dirty little details of their life and that kind of stuff. But there are exceptions to these because we need to be available in certain situations, right? Or we can be available, I should say. So, suspected abuse of children or those with limited ability to care for themselves, vulnerable adults, kind of already said that, they cannot legally enter into contracts. That's why we have parents give consent. And there's a whole bunch more to talk about there. We may go into it later, but in terms of who has rights over their children, the legal history and foundations of, there's more in the textbooks. I think it's really interesting too. The legal history of, children are essentially the property of parents, and how that's evolved into modern day legal standard is kind of interesting and weird also. But what that means is children can't make decisions for themselves until they're technically, I don't know, depending on where you are, 18, 13, 17, 16, whatever. Another limitation to confidentiality is it can't be guaranteed in groups. That's why we make such a big deal when we're doing group work, that we can that we have this conversation with people that we're not going to talk outside the group. And frankly, I revisit that pretty often. I did just the other day an internship class 4 weeks into the semester, and I was like, hey, there's a lot of talk about us as faculty and how we communicate with each other. And I just want to tell you what that means for me. And also, I hear things about you guys talking to each other about us, about talking to each other about other people. And I get that happens, and it's really not helpful at all. So let's have that conversation so we can talk about what good confidentiality means in the group setting. Also setting my own expectations for how I'm going to do that. That's my professional duty. But it's also important to the therapeutic process of the group that you have that conversation so that everybody else can be on the same page about it too. As it says behind me, can lead to difficult and potentially contentious situations. But, that's the nature of the work. So part of it. Another exception, or a couple more exceptions, when counselors need to protect against client lawsuit. When a client sues you, that essentially waives their confidentiality. So if they sue you and say, you didn't provide good services, and you can say, well, here's your records. Let me show you the services. Let me show the court the services I provided and let them make a decision about whether my services were adequate or not. So if a client brings a lawsuit to you, they waive that and they don't get the right to privacy anymore. That's their choice. So interesting. Information attained to decide civil commitments, like going to an inpatient unit against a person's will if they're under substance abuse, or if they're under the use of substance. My mind is blanking on the right way to say that. Under the influence, there we go. Under the influence of a substance. If they are experiencing delusions, there are those kind of situations where they may not be able to make their own decisions. And so some records can be released to say, I haven't been in this situation very much. If I can't think of a time that I have been at all, actually. So I don't really know exactly what kind of information. So if this were me, I would ask a whole bunch of questions. Somebody went to an inpatient unit and they called me and said, hey, we have a person here who says they're a client of yours. We'd like to know if there's anything we can do to help support them. And like out of the kindness of their heart, they're reaching out to that, which would be wonderful if that happened, right? Without something prepared in advance from that client when they were in a good state of mind, which is something we'll talk about later, as sort of like an advanced care directive. Don't have to memorize that term, but if you had that in advance, you can say, yes, they said they'd likely show up at your place and we have a release of information. They are a client of mine and here's what we talked about. If they don't, I would have questions about whether I would want to release that information, even if I thought it would be really helpful for the client to know. If I know that they're having a manic episode, delusions, if they're under a substance influence of substance or whatever, I might still err on the side of protection instead of releasing information. Maybe. That's when you weigh out all those consequences, pros and cons, right? So that's confidentiality and privileged communication. We're at 30 minutes, which is just about right. So now we're going to switch over to chapter 6, okay? Chapter 6, we're going to talk about records and things like note-taking and what kind of information do I put where. This is where there's going to be a bunch of terminology, and people use different words in the same way. They're almost like synonyms, and depending on the kind of documentation you see in law and legislation might be different in the way it's talked about in the ethical code. So it's super confusing. So I'm going to try and do my best to give you as much of that different kind of language and put these into categories for you to understand, but also note that you'll hear things talked about different ways. Okay. So this is going to be one of those really confusing parts. If not all of it's confusing, who knows? So there are differences between administrative information, like what you need to make appointments, a person's phone number, a person's address, a person's, like potentially maybe their diagnosis. Probably that's not even administrative information. So that take that one out. Forget I said that. Sometimes you can gather demographic information. It's if an administrator wants to know, like, who are our customers, who are the clients. Those things could be administrative, but there's a difference between that and clinical notes. Okay. What those are in specific, we'll have to talk about in more detail later. Taking notes is a really complicated thing because some people think of this on a spectrum here. Some people say anything you write down, you're held accountable to, so don't write too much down because it could get you in trouble later on. Other people say if it didn't happen, if you didn't write it down, it didn't happen. So we have to be able to document something in order to provide services. And there's just this pesky little thing about our limited memory that we want to be able to keep track of details and what's going on with our clients in order to provide good services, right? So we take our own notes too. So some say we take taking too many notes to self-protect versus taking too little to provide adequate services. So there's this spectrum here, okay? And I kind of mentioned that subpoint here about continuity of care. We also want to write down our own stuff, right? So you get to ask yourself these questions. Here are some helpful questions to be asking as you go along here. 1, who are you writing these notes for? So it's not really administrative information if you're writing it for your own memory to remember what you can talk about in the next session. That's client level, clinical case note kind of stuff. If you're writing something for other people, like if you're writing a report for the judge who told the client to come there, if you're writing a note home to a parent about what's going on in the session that could help them continue the practices that, like let's say mom brings in a kid and you say, yep, this child is responding this way because, this is what they could really use is XYZ thing. And you write down, okay, don't forget this, XYZ on a piece of paper. How you write that is part of the client's treatment plan. And if you're careful about who's looking at that and what kind of information you're sending home, it might be okay. And know that that's still counseling related material, right? It could be as simple as like, you develop a reward system with a parent who is, a child with nonverbal ASD or autism spectrum disorder. If you say like, well, we talked about using a reward system so they get 15 minutes of screen time if they do these different things or whatever. Even that is basically a treatment plan. But if you're writing that to a parent, you can write that in a way that's not divulging too much information about their clinical condition, right? So again, different kind of stuff, but you're also protecting that client's information in their treatment, okay? So another question to ask yourself is this the right place to document this information? If you're sending it home, putting something on a piece of paper to send home with a parent, that's a probably appropriate place to write it, like some piece of scratch paper or something. If you're writing your clinical impressions of the client on this piece of paper that goes home, that's probably not the place to do it, right? If you're writing in your electronic health record about too many details about what the client is sharing with you in session, not just symptomology about diagnosis, then that's probably not the place to do it. If you're sort of doubling your own progress notes, or that's another one of those terms, the stuff that you want to remember for later, if you're putting that into medical record and that's the same medical record that goes to insurance company, they may be getting too much information that they don't really need and you're divulging too much. So where things are put and how they're stored is really important, okay? We'll kind of break that down into like 2 categories though to make this a little easier too. there's not just administrative information versus clinical notes. We'll break that clinical notes down into what are you sending off to billing, symptomology, diagnosis information, and what are you keeping for yourself in your own record, which is like the details of their story. Those things are separate too. So we'll talk about that in a sec. Here are some other things that are administrative records: appointments, billing and payment accounts, signed documentation like informed consents, releases of information, intake forms where they sort of write like their medical history and family history and that kind of stuff. And then there's sometimes other information that you just need to sort of facilitate services. Sometimes people put like in their intake forms, they'll put things like assessments that then are used to lead to diagnoses. These are things that you should really strongly consider separating and keeping in different places because it's not related to their administrative, how the administrative services. That's related to a diagnosis that's made. So I've seen people kind of do these in multiple different ways, but they are different things. It doesn't necessarily mean if an agency is keeping those things together that it's inappropriate or illegal, but it's just worth being mindful of how that stuff is kept and stored. So, clinical case notes. Now, this is where we get into the difference between progress notes, the stuff that you send to insurance, which is different than the stuff that you keep for yourself. So you're going to hear words like case notes, clinical case notes, progress notes, DAP notes or SOAP notes, which we'll go over here. Some of you may be using those already in your work. But basically, these are the information. Basically, these clinical case notes are the information collected in sessions. So all of it put together, diagnostic symptomology. If you want to bill, if a client is coming in, they need to pay for services. Most funders, insurance companies, grants that are providing services, whatever, they want to know that they're actually serving people who have actual need, right? So that might be you provide diagnostic details, then make a diagnosis with that justification to say it actually exists and here's why. And that's the stuff that is involved in what you're trying to do with your client, because you need to be able to bill so you get paid and so they can get the services based on our medical system, right? Not everybody's going to be in a setting where you have to do that, especially you school counselors. You don't do any diagnosis. So this part you can kind of almost ignore, but you're going to want to keep your own records and keep those safe away from other administrators. But you may be keeping administrative stuff about how many kids you're seeing in a year, or what are the primary mental health conditions that you can keep in aggregate or like as a whole. Out of all your clients, most people are here for depression or anxiety or home situations or whatever. Those might be things you use for analysis that aren't specific to clients, something like that. So those can be kept separately. Genograms. We haven't talked about those in this class. I'll save that for when you go to one of your family classes or assessment. We'll talk about them in there. But it's basically just an assessment tool. Interpersonal details, those get collected during sessions. Thoughts, behaviors, beliefs, anything that you see on a clipboard or write down that's part of the content of a session, that's part of these clinical case notes, okay? You are often asked to say what kind of treatment you're going to provide to a person. In other words, if you are a CBT counselor, you're going to say, we're going to use some cognitive interventions to focus on these symptomatic behaviors or something like that. Your interpretations of what is happening based on your style, get my head out of the way, sometimes that becomes embedded in the treatment plan and the way you provide your services. So this is why it's so important that we talk about theory and understand a little bit about it, because it's also how you talk about the services that you provide. There's a way to do it in depth, which is what you do on your papers while you're here. And there's a way to sort of talk about it just enough so that you're not giving out more information than you need to when you're doing things like writing it in record and billing for services and that kind of stuff. We're not going to spend a ton of time on DAP notes and SOAP notes, but DAP stands for Description, Assessment, Plan. Sorry, I had a little brain fart there. A description, assessment, plan. SOAP note is essentially the same thing. It just means subjective description, objective description, assessment, and plan. What those are, oftentimes this is the kind of documenting you do after a session. You do an intake where you fill out a bunch of information. Then after each subsequent session, you say, here's where we're at, here's what we did, here's why I can justify billing insurance, and you send it off. With my DAP notes, depending on the setting where I'm at, sometimes I'm incredibly descriptive, and that's where I write in my like the content of the session so I can remember it next time. It's where I keep most of those records. Other times I'm very sparse. I only say, here are the symptoms, here's the intervention we used, and here's the diagnosis or something like that. So it depends on your setting and how you write those things and what you think needs to be protected based on who's seeing this information. That really matters, okay? Again, you'll get help from your supervisors. You'll be trained when you get on site of what kind of things to put in and where. Take a little bit of a detour for just a second. We as a school oftentimes hear the feedback from sites and counselors out in the practice. They're like, people aren't coming out ready to write about this stuff. And this is part of the challenge, is because people have such different practices based on whether you're billing insurance or whether there's no billing at all. If you're working in a school, every school has their own institutional policies about how information is stored and what's shared with whom. And so it's really hard to get you trained to do that kind of very, very specific and nuanced situational kind of writing without just going out and doing it. So we do the best we can to sort of talk about, how do you think like a counselor? How do you write in this very technical counselory kind of way? How do you understand how to write about your own theoretical perspective? That's why we do so many of those practices here, so that when you get out, you can use that, synthesize it with your specific needs of your site or school, and then be ready in that sense. Site supervisors don't always understand that process. Students don't always understand that process. And even us faculty sometimes are like, what the heck are we trying to prepare you for? You know what I mean? So it's just so confusing. For me personally, this took me, and it still takes me, whenever I go to a new place, it takes me so long to say, like, what do your insurance companies want? What's the culture around here, and how do you write about this stuff? Because who your supervisor is and your fellow therapists are, they're all going to have this learned culture of what expectations are, and it takes time to figure that out. So just say that out loud for your benefit, that if you get confused about this, it's okay, and it just takes time for everybody. I'm having a little brain fart moment here. I'm going to look this up because I thought I've had this conversation with a few people who literally should know better, but HIPAA, it's the Health Insurance Privacy and Portability Act, not the Health Insurance Portability and Accountability Act. I'm second guessing myself now, and I have to figure out if that's true. Hold on a second. I'm going to see if I can find this fast enough. I've already talked a little bit about what HIPAA is. So I'm not going to spend a ton of time talking about that. But see if I can do this while I'm talking fast enough. It's going to be annoying. Sorry. Here it is. Health Insurance Portability and Accountability Act. Okay. I get this wrong apparently all the time. I'll have to figure out what to do about that. I'm not gonna start recording this whole thing over again, and I'm not gonna edit this out. These are those moments. Some of you have seen these in multiple classes, but these are those moments where, to me, my ego says, "Oh crap, I've made a mistake. I need to cover up or compensate for it." And there's another part of me that says, "No, mistakes happen. Even these dumb mistakes like this one. I should know better, and I should have this stuff figured out. And I really want to look smart and be smart in front of you guys." At the same time, it's okay to be humble and say, oh man, that's a mistake that a lot of people make, and I'm making it too, and that's just fine, right? So it's a failure. It's a mistake. I've messed up, and it's okay. So I'm just kind of showing this out loud because as I'm sitting here recording this alone in my office, I'm like, I'm embarrassed, and I could totally redo this and not look like an idiot, or maybe I'm just an idiot and that's okay. So I don't know. You choose how you want to deal with that one. But the spirit of it remains the same. Counselors must provide client access to their own records, right? Remember, it's their story, it's their information. You have to be able to do that, even though you sometimes might want to protect them from themselves. And there are certain circumstances and exceptions where you may want to do that, but it's their stuff, right? Clinical case notes are considered psychotherapy notes under HIPAA, okay? So here's another one of those terms that I haven't said yet, psychotherapy notes. Clinical case notes progress notes, psychotherapy notes, just case notes, DAP notes, and SOAP notes. All of these things are kind of describing the same sorts of things, and some people differentiate them. Psychotherapy notes, the way it's being used here, is often like what you're writing on your notepad when people are telling you about their life and their situations. You're writing the words that they're using, you're writing the names of family members that you need to remember, you're writing situations that have happened throughout the last week of their life or something like that. You wouldn't write that when you're writing a DAP note about justifying a diagnosis or something, right? But so in other words, psychotherapy notes, those really personal details, have a higher level of protection than the symptomology of a person that leads to a diagnosis. However, under HIPAA, all of that is protected, all right? So all of that is considered part of the medical record that gets protection, okay? So the reason for HIPAA is to protect clients, and so they cast this wide net and said all of these things really need to be protected and are important. And then it gets complicated in the exceptions of this different circumstances. FERPA is something that for you clinical mental health counselors, you won't have to pay too much attention to, but for you school counselors, you might. If anybody works in a college setting, well, I should say this. If you work in a school, you'll have school counseling classes that tell you a lot more about different school information and laws that apply to school. The one that comes to my mind because of my training is the Individuals with Disabilities in Education Act, or IDEA. That's one of those that's really relevant to school situations. If you've ever heard somebody being on an IEP or a 504 plan, those come from laws that are specific to K-12 schools. Not 504 plan, but it applies in that situation. It's a non-discrimination. But FERPA relates to mostly to higher ed, and that's not entirely true. There are some exceptions to that. But basically what it means is that families of minors have the right to inspect, review, and challenge contents of records, and to have written authorization before copies are transferred to third parties, okay? Again, children are the property of their parents, so parents have the right to that kind of stuff. So that applies to you school counselors. If you're working in a college setting, though, once a person turns 18, that's why it's such a big deal here. Once they turn 18, FERPA protects the students from families calling in and saying, this is so funny when it doesn't happen to me ever because I teach in grad school, but when I have other faculty who are teaching, college freshmen, and someone's parent calls and said, you gave them a D on their assignment, I want to know why. And you're like, I can't really tell you about that because they're an adult and they need to come talk to me, right? Like I laugh about it, but it's also, I don't know, maybe this is harsh language, but sort of failed parenting and preparing kids to be ready to have those conversations for themselves, maybe over-parenting beyond the age when they should be, right? It's just personal opinion, but it also puts us into weird situations as faculty of like, we can't tell you that. It's not your right. You don't have that right, People can give written authorization to release that kind of information, though, to third parties, which is most often family, but not always. Dependents are defined as children of those, let's get out of the way for this one, children of those paying over half of the support in the previous tax year. So if any of you guys work with blended families or, I don't know what the right term is, but divorced parents or something like that, custody issues. If someone comes in and says, I'm the biological father of so-and-so, I've lost all my custody rights and I only get to see them on visitation once a year, does that mean they have rights to that client's record? Well, no, not according to this act. And so that's why some of the nuances of these situations, it just takes so much time to go figure out what that means in your setting. Why it's so hard to talk about this, because if you're working in a sort of adjacent criminal justice setting, these things apply probably more than if you're just in a regular old outpatient therapy center or something like that. Or if you're in a school too, it's different. So there's more to learn about that. Also, you'll get more of this conversation if you take the, I talked about this in the chemical dependency class over the summer, and if I teach it again, I'll talk about more of this too. But federally funded substance abuse programs have different exceptions to confidentiality. There's just different ways because of the potential for medical emergencies. Doctors working in the same facility as therapists and social workers who are coordinating services together. There's just a different kind of need to share certain kind of information, and records need to be shared. Therapeutic like records need to be shared with doctors to help integrate those services because of the nature of the illness. So if the government is federally funding those kind of programs, they also have an expectation that they should be able to come in and audit those records to make sure they're being people are practicing appropriately. So just note that if you're a private practice clinical mental health counselor and someone comes to your door and says, like, I need to check on your records, you're like, no. But I'm an attorney. I still know. But I'm an auditor. Absolutely not. You know what I mean? Unless you have a subpoena, you're not coming in here. Auditors for federal government programs, or for programs that get federal funding, do not need the subpoena every time they want to go in and do an audit. So there are exceptions to that. So there's a few other things there too, but you'll get that covered in other stuff. I'm going to scan to see how close we are to the end here. We're almost done. Handling records. There's no universal requirement for length of retaining records. Okay, how long do I have to keep records after a person is done seeing me? Generally, it's 5 to 7 years. Some people just on the safe side say 10, depending on how much space it takes up in their life. As far as like what's ethically appropriate, different professions have different expectations. So that's one that you'll have to think about later. But at least think about how long do I keep these records, because sometimes there's a really helpful need to do that. Sometimes states have their own legislated guidance on this. Sometimes they don't. Again, this is part of the challenge for those of you that are like, I want to start a private practice. These are the things you have to figure out and learn in advance to make sure you're set up and ready to do things that are according to rules. If you go to an agency, they'll have a policy. They'll have thought through this stuff. They'll have administrators who have gone through learning about FERPA and, the substance abuse laws and that kind of stuff. So more on that later. Last slide, I believe, right? Yeah. Last one. When it comes to subpoenas, the legal term for collecting records during the initial process of a legal proceeding is discovery, discovering all of the evidence and facts that we need to be presented with on both sides. And then there's the testimony, which is like explaining it and talking about it and making your case and all that kind of stuff. If you have to go through this, some of you will more frequently, even maybe potentially an internship, if you're working at a site that just is sort of criminal justice adjacent, if you're working with court mandated clients, stuff like that, you may have to, you'll get support and help with your supervisor of like, what does that look like and how do we do this? The first thing to know is don't freak out. And if you're in those situations, work with such integrity that you don't have to try and cover up something. And if you're scared and you're not sure what is covering up or what details you can give out, whatever, just tell the truth. Telling the truth is going to keep you safe 9 times out of 10. And even if you make a mistake with the best intentions and you show that you're making the best efforts you possibly can to do things according to rule, you'll be okay. It's incredibly important to have the help of an attorney who can support you through process if you're not accustomed to doing that. Like if you're working in a court mandated program, you don't need an attorney on your side to help you with that. You'll likely have somebody that you can talk to, but if you're in your own private practice, make sure you have an attorney who you can talk to about these things. But tell the truth. Just be honest. Be a person who's not scared of the work that you're doing. And so we'll just start with that. I guess I already mentioned the second bullet point. Discovery is the process of gathering information prior to trials. Oftentimes, it's only like 1 to 2% of court cases actually go to trial. So if things come up and you get a subpoena or you get something that says we need to collect records, it doesn't necessarily mean you're going to have to go to court. It might just mean you might get deposed at the worst, and that's a whole thing if you want to talk about that one. But most of the time, things get settled outside of court because legal proceedings are expensive, and most people don't have or want to spend all that money. So I'm not going to spend a ton of time talking about it in this class, like that sort of the legal system and how it works. I used to work in the rehabilitation context in forensic settings, so I learned a little bit about the legal process and that kind of stuff. I've been deposed, I've been done testimony and trial, and it's just a whole different thing. So that's, for most of us, we don't have to worry about it as long as we're taking all this in and saying, I'm gathering all this information. It's a lot of information, but I trust the people who are going to support me and supervise me to help me understand this in a progression. So by the time I'm independently licensed after I graduate, spend my 3,000 hours getting ready, by that time, I'll be ready enough to be safe. And that's the important thing. So don't worry too much at this point if you can help it. Kind of me to say that an hour into the conversation after I overwhelm you with so much stuff, right? So again, back to legal proceedings. Follow the rules exactly. Again, ask an attorney. Interrogatories. I've used the word subpoena, and that basically means like, give me the records. The judge says you have to have them. An interrogatory is a document that you might get that says, we don't really need you to like spend all your time coming in and getting deposed and doing all this stuff, but we'd like to get some information from you. We need you to write it down. So it's like telling your side of the story in report form instead of having to like talk it out loud, which many people prefer because then you can write it down. You don't have to be like being grilled by some opposing attorney about your practice or potential malpractice or whatever it is. So just note that term, interrogatories, and we're not going to talk about it anymore in the class or in the program, but you can ask more about that later. Look into it if you need to. If you are asked for records, never forward originals. Make note of that. Send copies of everything, but keep all of yours. And even if you're required to send things, you may have to do some work. This is annoying, but you may have to do some work to separate certain kinds of information or redact certain things that need to be kept private if things are jumbled together. Again, there's a lot more, but get myself out of the way for the last line here. You'll need to do more work to read up on this stuff if you find yourself in this situation. So ask an attorney, ask an attorney, ask an attorney, have a good supervisor who can give you, who can help you find a good attorney. So don't be scared of that. Attorneys are, they can sometimes be scary because we, as counselors, we more often than not tend to be pretty like, as helpers, a lot of you use the word people pleasers. We're a little bit more passive and we're willing to sort of listen to things and let strange situations happen in front of us because that's how we need to do therapy. Attorneys tend to be more assertive and aggressive, and I guess assertive is the best word. But that doesn't mean they're inhuman. That doesn't mean they're not there to help and support you as a therapist or clients to help deal with their situations too. So they're not the enemy. They're not, some of them can be kind of scary, but there's great people out there who are lawyers. And so it's not something you need to be too worried about. In fact, when you find a good attorney who can help you, it's so nice. It's so nice to meet somebody who's like, I can't deal with all the legal stuff, so I need your help. Can you help me? And they're like, yeah, of course I can help you. And then you're like, good, that takes a weight off my shoulders because now I'm not burdened with all of the legal stuff. I just need to practice and to focus on my practice and my clients. I need to outsource that part of it. So it'd be really helpful. Okay, that's it. If I haven't said this to you before, this is one of my favorite lines that I share with people quite often is your degree is just a piece of paper. Your education is seeing your behavior. The reason why we spend so much time in this program focusing on self-reflection, and I'm asking you all these questions, is that you'll come out of this. If you can be academically successful and say all the right things on paper, you can get a grade, you can pass a test, you can do all those things that really smart people need to do. But just because you're smart doesn't mean you're interpersonally savvy, street smart. It doesn't mean that you are applying and synthesizing the wisdom that you need to practice morally, ethically, and to really be just a decent human being. So being a decent human being is how you treat other people. What you get as a credential is just a piece of paper, right? So don't use that to hold over clients and say, you need to trust me because I have a degree. No. If you're a bonehead, they don't need to trust you at all. Same thing with me. If I'm just being a total bonehead, yeah, I make mistakes, of course. And yeah, sometimes I act silly and say stupid things. And if you still deem me, I still have to earn your trust and be trustworthy based on the way that I behave and the way that I treat you guys. So that's really the important thing, not just that I'm a doctor of education, right? That means nothing when it comes to the boots on the ground work. It means a whole lot of things in other settings. But when it comes to human interaction, I have to work just as hard as you do with your clients to earn your trust in class. So with that said, I will leave it there and I will talk to you guys next week or in class before next week. All right. See ya.